Moore Law is underwritten in the public interest by the Moore Law Firm, a legal professional association. This is Moore Law on Fox 19.
Drinking and driving is a scary combination. On one side, will a DUI cost you money, your license, and potentially jail time? On the other, more sobering side, is the possibility of hurting or killing someone while driving drunk. What recourse do victims have? If you have a question about a DUI-related arrest or injury, give us a call, 513-421-4691. And back in your chair this week, Don Moore, how are you?
I'm doing very well. In fact, I made it back in my chair despite skiing without crutches.
Well, I'm very glad of that.
So that was good. It was good to have a little time off. And
I know you worked a lot. I don't think you take a lot of time off.
Well, I wish I could have taken more time off, but you know, you do the best you can. Hey, today we really have a great guest. Chuck Strain, welcome.
Thank you. It's great to be here.
It's great to have you. Chuck has been practicing law for over 30 years. He does nothing but DUIs. He really knows them well. He goes to Harvard every year to keep updates and give updates regarding the DUI, what the portion of the law he does, and he teaches other lawyers all the time. So this is something he really, really knows well. I'm glad you're here, Chuck.
Thanks. I love to talk about it.
And the day after St. Patty's Day, what an appropriate day to talk about DUI.
Unfortunately, probably right. I'm sure the phones are ringing.
It's been a busy weekend.
I'm sure. Well, when you talk to people, what are some things, you were discussing three things people should never do if you're pulled over and you've been drinking?
Well, never be rude to the officer, never resist. If they're telling you to do something, like get out of the car or to put your hands behind your back, don't resist that. But maybe the most important thing is never lie. A lot of people in that situation, when the officer asks them how much they've had to drink, they say 2 beers or they say none. And if those are lies, that'll likely get you in big trouble.
And things will just, I would assume, escalate, right? Better to say nothing than to lie.
It's better to say nothing, and you could just flatly refuse, or you could say, please, officer, must I really answer that question? That's a little softer way to put it.
But you said that, never say that you haven't been drinking. I've always heard, when you mentioned the 2 beers, I've always heard that people say, I've had 2 drinks. Like they think that that's the appropriate amount.
Right, well, if you say that, the officer's gonna know first that you're lying, and second, that you're not a very creative liar. And third, that you've probably had 4 times that much.
And fourth, you've just admitted drinking.
Well, that's true, and it's possible, though, to make an admission and gain some ground by that because you gain credibility with the officer and maybe in court later on, too, if you are a person who tells the truth. Remember, George Washington and the legend of the cherry tree, we learn about him even before kindergarten because he couldn't tell a lie, and it would be better to say, I'd just rather not comment than to actually tell a lie.
Very good.
Great. Let's go to the phones. Let's start with Kim in Indiana. Good morning, Kim.
Good morning. My question, I have an alcoholic family member, and every day I pray that he gets arrested for DUI because I think that's going to be his only step towards getting help. The question is the family, when someone is arrested for DUI, is the family allowed to address the court and advise them of the issue and maybe request help for that family member?
That's a great question.
That's interesting.
That's a very good question.
I think it is too. And yes, the family probably should get involved. An event where a person is in trouble is something that will get their attention. And at that point, maybe the family that they've been ignoring for a long time, they'll start listening to them. They might hear the same sort of thing from the lawyer who's trying to counsel them to get out of trouble now and stay out of trouble in the future. Usually courts and prosecutors like it a lot more if you've already turned over that new leaf and you're already taking care of the problem so they don't have to slap you upside the head to get your attention.
But, Kim, her family member hasn't been arrested ever. But, sometimes you hear about these people with 10 or 12 DUIs. How in the world are they not in jail?
Well, they are in jail for a while, but you can't keep them there all the time. And as a general matter, our society doesn't want to pay to keep them there all the time. Besides it being an unconstitutional problem, you can't just lock them up forever.
Chuck, would you tell us about the steps as far as a repeat DUI? Like, for instance, you get 1 DUI, you got to do how much time?
Well, on first DUI, if you're convicted, you have to do at least 3 days or 6 days in jail, depending on what happens on the breath test, and it could be up to 180 days. On a second offense, the minimum jail time is 10 or 20 days, depending on the breath test, and the maximum is 180. And a third offense, while still not quite a felony, is a minimum of 30 days and a minimum of 30 or 60 days and a maximum of a year.
Now, when you say second and third, in what period of time are we talking?
That's generally looking back a 6-year period from the date of the new arrest. If in that last 6 years you've had a prior or two, then that escalates what the judge must do at a minimum for a penalty if you're convicted of the new one.
Okay. All right, let's get back to the phones. Let's see, we have Brad in Hamilton. Go ahead, Brad.
Yes, I got a DUI last Friday, and I was in my yard, actually. I was burning out my yard. Anyway, they gave me a DUI, then first they started talking about 3 days, then they went back to like 1993 or something like that, and then they went from 3 days to 6 months, and kind of jumped all the way up to a felony to 18 months.
Well, Brad,
in prison, I mean.
First you mentioned that it was in your yard, and I'd make the point that it's illegal to be drunk driving anywhere in the state of Ohio, and that includes your backyard, includes a golf course, it includes the streets, of course, or any parking lot. Now, you talk about the penalties. Well, they certainly can look back to 1993. They can look back to 1903 if you had a DUI back that far. They can look at those, and the judge probably should take into account anything, no matter how far back in history, but they're required by the statute to take into account and enhance the penalties just for those in the last 6 years and sometimes those in the last 20 years.
Okay. All right, we are going, did you want to add something to that and I cut you off?
No,
Okay.
you're good. I mean, one of the things I think, just the business about operating, he talked about being in his backyard. You don't have to actually be driving the car like on a roadway or with it in gear to be convicted of a DUI, do you?
Actually, that's the way it used to be done.
Yeah.
Prior to 2004, you could be sitting in your car with the engine running, maybe to keep warm in the wintertime or listening to the radio, and that would have been a DUI back then. Since 2004, you have to move the vehicle. Now, that could be that an officer comes upon an accident and you had previously moved it, but right now it'd be just physical control of a motor vehicle, less than a DUI. It's like a non-moving DUI, and the penalties are less.
Okay, very good.
We're going to take a break. We'll be right back talking about DUI. Give us a call, 513-421-4691.
Welcome back to More Law on Fox 19, your legal questions live, with local broadcaster and award-winning reporter Deb Haas and Cincinnati personal injury attorney Don Moore, recognized by Ohio Super Lawyers. More answers, more help, more law on Fox 19.
All right, we will go to your More Law Connection now, where attorney Dan Moore is answering viewer emails. Good morning, Dan.
Hey, Deb. Good morning. Today our first question is from Randy. He wants to know, my sister was hit and killed by a driver while she was crossing the street. Her adult children have hired a lawyer, but no one else in the family thinks this person is the right choice. Is there anything we can do to get a different lawyer involved? Okay, this is a tough situation. I've been involved in a few of these. The thing with when you have somebody killed as a result of another person's negligence, the family typically must go to probate court and get a personal representative for that estate appointed. That person is the one charged with the responsibility of hiring the lawyer. Now, once that person hires the lawyer, generally speaking, there's nothing anybody can do about it. That's the person they choose, and that's the person that typically the court's going to approve. Now, if there's a special circumstance where that personal representative has done something that should disqualify them, you can bring that up to the probate court and replace them. But that's typically not going to be something that you're going to be able to do unless you have a drug problem or some crazy scenario there. The other thing you can do, if the personal representative hasn't been appointed yet, you can apply and get yourself appointed, and then you can make those decisions yourself. Deb, back to you.
All right, thanks a lot, Dan. And we're back talking about DUI with our guest, Chuck Strain. Thanks again for being here.
My pleasure.
All right, let's head back to the phones. Let's see, first up we have Gregory in Fairfield. Gregory, you got a DUI, you said, but you don't think you deserved it?
Yeah, about 2.5 years ago, I was with friends, and see, I don't drink. I go to church, and the thing is this: I was coming home to Kings Island from friends from the haunt, and this cop pulled me over, and he said somebody stopped him and said that I was weaving and going all over the road, and that's not true. And then he pulled me over, asked to get out of the car, and then he said, "Well, you drinking?" And I said, "Well, no, I'm not." And he gave me a breathalyzer test. He said the batteries were dead. And then next thing you know, I got arrested for DUI for something I didn't do. I was wondering, is there anything I do to report this cop?
Well, how long ago was this, Gregory?
About 2.5 years ago.
Well, maybe it's a little late to be reporting it now, but you were eventually convicted of that DUI, is that right?
Yeah, what can I have done about that to have reported that cop?
Well, you can always file a report with the police department, and their internal investigation can look into it. But it seems to me that maybe your more important problem is the DUI charge. And I hope you had a lawyer. Did you fight that case?
Yes, I did. I had a lawyer out of Red Lion.
Now you said you hadn't drunk anything, but had there been any prescription medications involved?
Yeah, there were some in my pills, and he started reaching in my pocket and pulled out the pills, and then he says, "Well, you're selling drugs." And I said, "No, I'm not."
Well, selling drugs or not, one important point that many people don't know about is that you can be charged with a DUI and convicted of a DUI if what is impairing you is medication, and that is even true if it's prescribed for you and you're taking it according to the prescription. So if it's a kind of medication that causes you to have difficulty driving, then it's illegal.
Go ahead, Don.
So Chuck, don't most of the statutes talk about either under the influence of alcohol or drugs?
Alcohol and or drugs. So it could be a combination of the two, or one or the other.
Okay.
Okay. Let's check in with Sue in Kentucky. Good morning, Sue.
Good morning.
Go right ahead with your question.
My son was picked up with on a DUI a little over 5 years ago in Ohio. And Ohio had Kentucky to pull his license. Now, Ohio is telling him that he has to have proof of insurance in order to get his license back. So the question is, how does he get insurance when he doesn't have a driver's license?
Well, I think it would be difficult to get that. That's a question for the insurance industry. But I think he's just got to give it a try. And Ohio won't restore his privileges. No state, for the most part, will give privileges to somebody if they don't have insurance. Sometimes it's difficult to get the cart before the horse, but get that insurance first. Maybe you'll find an insurance agent that will give him insurance.
Don, you wanted to add to that?
Yes. Sue, there's a specific thing you can do, and that's have him call your insurance agent if he lives with you. If he doesn't live with you, if he can't get insurance before he gets his license, he can probably get an SR22 bond. That's a step in the right direction. That's a legal requirement, one or the other. He gets the SR22 bond through an insurance agent, then he'll be able to apply for his license, get it, and then get straightened back out and perhaps get normal insurance if the agent will give him normal insurance in the first place.
I'd agree.
Okay, all right. We're going to go back to Dan Moore real quick with another email question. Go ahead, Dan.
Great. Our next question is from Theo. He says, do limit laws apply to private sellers or just car dealerships? In most states, limit laws simply apply to the purchase of new vehicles. So if you're talking about buying a car from the guy down the street or off a ad on the internet, limit laws don't apply to those folks. That doesn't mean you're without a recourse. I mean, if you buy a car that is a piece of junk and it was represented to you that was a decent car, then you have a breach of contract claim potentially. You have a claim for fraudulent sale. There are other things you can look at, but the limit laws, the specific laws that are codified in the books, typically don't apply to those situations. Okay, if you have a question, as always, go to the Fox 19 website, click on the More Law button at the top of the page, and you can fill out the form, submit it, and we'll do our best to answer the question like we do every week. We look forward to seeing you all next week, and Deb, I'm out of here.
Thank you, Dan. We're going to take a break right now. We'll be back talking about DUI. Give us a call, 513-421-4691.